A very warm welcome, everyone, to the Maritime Education Podcast. My name's Barry Sadler, and to those of you who have just discovered us, welcome on board. I hope you find something here of maritime interest to you. And of course, to our regular listeners, welcome back to the podcast. I'm going to talk today a little bit about Civil Liability Convention, the 1992 Civil Liability Convention, which fundamentally caps the amount of liability that a ship owner has if a tanker is involved in an oil spill incident. Now, the fact that it's a tanker means that that oil spill incident can either be cargo or it could be bunkers. But nonetheless, if it is a tanker, then this 1992 Civil Liability Convention kicks in. Now, the reason that I wanted to talk about it was because I subscribe to a lot of update emails from various bodies, P&I clubs, classification societies, flag states. I get emails through on a regular basis advising me of some change of the law or some change in policy of that particular organisation. But one came through very, very recently, which was titled Guidance for Member States on the Definition of a Ship under the 1992 Civil Liability Convention. Now, definition of a ship, to me, meant that we had a very, very serious, shall we say, clash going on between the definition of a ship under that convention and the definition that somebody had tried putting in court about a ship. Now, when I started to read into it, it opened up a very, very interesting series of debates regarding the Civil Liability Convention. And so I started to look into what the problem was. Now, we fundamentally have two conventions that limit a ship owner's liability in the case of spilling oil. Now, first of all, we have to ask ourselves, why do we even have such conventions? Why are we limiting the liability of somebody who has polluted the marine environment? This is all about risk at the end of the day. If we do not limit a ship owner's liability for such incidents, then owning ships and running ships becomes too higher a risk activity. And by limiting the liability of a ship owner, it allows the ship owner to trade with their vessels under the protection that if the worst were to happen, that they would not be overly liable for oil spills. Now that sounds terrible, doesn't it? If a ship owner spills oil, we would expect that ship owner to find the money and to clean that oil up. But oil spills can go into millions, if not billions, of both costs for cleanup and costs for compensation. And if there were no protection to the ship owner against having to pay out billions of dollars, then the ship owner would see that risk as too high and would not want to run their vessels around the world, or perhaps not want to run their vessels to particular parts of the world that uphold these liabilities or do not uphold these liabilities. Therefore, we have two conventions that come into play. The one that the article that I read was written about is the 1992 Civil Liability Convention, and it primarily targets oil tankers, whether they be laden or unladen, for capping the liability on the spilling of either cargo oil or bunker oil. Now, at the end of the day, the type of oil that is covered by the 1992 convention is what we call persistent oil. Persistent oil is oil carried as cargo and bunkers that would be persistent if it were released into the sea. Some oils, I'm sure some of you have seen, if we spill diesel, for instance, whilst we are filling up a diesel tank on a yacht or something like that, we do get a spill into the water, but that spill in the water will very, very quickly evaporate from the surface. And by applying some very, very modest chemicals or agitating the water, this oil will very, very quickly disperse. Persistent oil is very, very different. When we spill persistent oil into the water, regardless of what we do, that oil will be still in the water and will cling to whatever the water touches. Now, clinging to whatever the water touches, we've seen a lot of pictures of oil spill in the past, and the oil will cling to the beach, it will cling to other vessels, it'll cling to wildlife, particularly birds whose feathers will absorb the oil very, very quickly. It'll cling to people, it'll cling to people's possessions, and so persistent oil is oil that will not naturally disperse. Now, under the Civil Liability Convention, the liable party is the registered owner only. Now, this is very, very strict channeling of this liability for cleaning up the oil in this context. Now, the alternative to the Civil Liability Convention for ships other than tankers is the 2001 Bunker Convention. Now, the Bunker Convention targets non-tankers and basically caps a ship owner's liability in the case of a non-tanker spilling their bunker oil. Obviously, it's not going to be cargo oil because it's a non-tanker, so it's not going to be carrying any oil as cargo. But the oil it carries on board, oil that's used for propulsion, operation, lubrication, this type of oil is covered by the 2001 Bunker Convention. Now, it's interesting that the Bunker Convention, at the end of the day, targets the ship owner. Now, the registered owner and the ship owner are actually two different people. Under the 1992 Convention, the registered owner is literally the owner of the vessel. The person or entity that is registered as owning the ship is the only liable party. Under the 2001 Bunker Convention, this spreads out to include the ship owner. So this includes the registered owner or the bareboat charterer, manager, operator of the ship. They can all be defined as the ship owner under the 2001 Bunker Convention. So there's a much broader scope of liable parties under that convention than there is under the Civil Liability Convention. But what's the catch here? Why is this Civil Liability Convention so unique when it comes to being able to claim from a ship owner? And the reason is that the capping of the liabilities under the Bunker Convention for ships other than tankers is much, much lower than the capping underneath the 1992 Civil Liability Convention. There is a reason for this. Now, the old standard under the three limitation tiers fundamentally limited the ship owner to between, let's say we're talking about a 50,000 gross ton ship here, just to give some sort of consistency to the numbers, shall we say. The 1996 limitation liabilities, which kick in on the CLC, basically for a 50,000 ton ship, limited the liability to around $12 million US. Nothing. Absolutely nothing, of course. Spilling oil from a 50,000 gross ton ship is very, very quickly going to escalate above 12 million, not just for the compensation to people affected, but the cost of the cleanup as well. This was changed in 1996 to what we know as the modern standard, which basically, for that same ship, over doubled the limit, all the way up to a 30 million US dollar limit. In 2012, it increased even further by what they called the enhanced standard, and that increased the 1996 limits by 51%, mainly to account for inflation. So the CLC does have some high limits already applied to it. These same limits are applied to the Bunker Convention, and at the end of the day, whether you are claiming under the CLC or under the Bunker Convention, these same limits apply. But what is fundamentally different under the CLC is that we can breach these limits, and the breach is paid for by an international fund. Now, an international fund is only available when we are fundamentally talking about a claim under the 1992 CLC, and is not available under the Bunker Convention. So at the end of the day, if we are talking about, let's say, a catastrophic spill from a 100,000 gross ton ship, okay, so I know I've doubled the size of ship, but it gives us a much better indication, a much more up-to-date indication of the sorts of limits that we will reach. Okay, so under the 76 convention, we're going to reach about $18 million. Under the 96 convention, $43 million. And then under this enhanced convention, the 2012 amendments, $65 million. So the Bunker Convention, which has no international fund available to it, if a ship other than a tanker were to spill bunker oil, then the owner's liability would be limited by those 2012 amendments to around $65 million. All right? That's how much in total the ship owner would have to spend. When we say the ship owner, that opens up another thread of conversation, because at the end of the day, the ship owner will be insured through a P&I club normally. Now, the trouble with P&I clubs is that P&I clubs are there to remedy the ship owner. So what we mean by that is that the ship owner has to spend that $65.2 million on clearing up the oil out of their own pocket. The P&I club would then come along and reimburse the ship owner that $65.2 million. Now, that is a strange thing. It's a strange, shall we say, principle that there is in the in marine insurance, and at the end of the day, that principle is applied by P&I clubs to most claims under the Civil Liability Convention. So, where does CLC differ? Well, if you've had a ship spill oil in your jurisdiction and people need compensating and the government wants paying for cleaning up the oil, then you're obviously going to seek the biggest liability you can from the ship owner. If you go under the Bunker Convention, that liability will go all the way up to, for a 100,000 ton ship, as we've just discussed, $65.2 million. Under the Bunker Convention, there's no additional fund to top that off. Now, it's different under CLC. If the vessel were a tanker, either a laden tanker or, and this is what prompted the article that I read, a tanker that was on a ballast voyage but still carrying residues from a previous cargo, then it would not be subject to the Bunker Convention. It would be subject to the 1992 Civil Liability Convention. And that means that we get a three-tier approach to the compensation. So basically what happens under CLC is that you've still got that limitation of liability to $65 million, which comes in from those 2012 amendments to the limitation of liability limits. But you now have on top of that under CLC an international fund which is used to top off the cost of cleaning up the oil. Okay, Now, there are two further funds available to that. Okay, so first of all, your ship owners fund, your tier 1 fund, that's capped, and we've talked about that. The tier 2 fund, an international fund kicks in, which basically raises the amount available to clean up the oil under the CLC and the International Oil Pollution Compensation Fund. Tier 2, the 1992 fund as they call it, that would increase the ship owner's liability up to approximately $290 million US. All right? So we're starting to see much bigger numbers under CLC once that international fund kicks in. There is also a supplementary fund that have signed a protocol in 2003. There's only 33 countries that have signed that, but it does include the UK, most of Europe, Japan and Australia. The total pot available to compensation and liability jumps to a massive $1.07 billion. Right? So if you think about it, although the ship owner is capped at 65 million, these international funds, and only under the CLC convention, not under the bunker convention, these international funds would kick in and would make approximately available in the form of compensation to people that are affected and to pay for the cleanup of the oil. That fund would stretch all the way to 1.07 billion. Now, that sounds like a lot of money, okay? $1 billion, that's going to buy you an awful lot of oil cleaning, and it's going to compensate an awful lot of people. But just to put things in perspective, some of you may remember the story of the Hebe Spirit in 2007, which was a ship that was anchored off of South Korea and involved in a collision with a crane. That spilt 11,000 tons of oil, but resulted in over 128,000 claims, which totaled over 2 billion. Now, Korea at the time had not ratified the supplementary fund at that point, so claimants could only claim up to that tier 2 fund, international fund of 290 million. So they received a fraction of their proven losses, and then the money ran out. That's from a tanker. At the end of the day, if that Hebe Spirit spill had been from a non-tanker or a tanker that was in ballast that could prove no residues, then there would have been a massive shortfall. Okay, because at the end of the day, the ship owner would have been limited to that 65.2 million liability, and then anything above that would fundamentally have to be reimbursed by the government and therefore the taxpayer of the country involved. Now, obviously, these levels of compensation have been rising throughout the years. They rise throughout the years for several different reasons. They have risen throughout the years mainly because of inflation, but also because of the cost of recovering oil and the ability to claim for losses from oil have increased, particularly the ability to claim from losses, as people have become much more aware of the funds that are available in order for compensation to be paid to people that are directly affected by such an oil spill. These limits of liability, be it a limit of liability under the Liability Convention, which applies to the Bunker Convention and the CLC, which limits the ship owner to 65 million, or be it a limitation of liability from the International Fund, which, as we've seen, the most recent of which limits the liability at $1.07 billion. Whatever that liability is, people will do their utmost to breach that liability. In other words, they will try their utmost to break the liability barrier. Now, the international community intentionally made those liability limits virtually unbreakable to ensure that insurance would remain affordable and available to the shipping industry. But there are loopholes and legal strategies that can be used to bypass the various caps that we've talked about here. And it was in investigating this that I started to read about a very, very familiar oil spill, which a lot of you, I'm sure, will be aware of, and that's the oil spill from the ship, the Prestige. Now, one of the ways in which the caps can be broken is known as the recklessness and knowledge trap. This basically means that the losses resulted from the ship owner's personal act or omission and was committed with intent to cause such loss, or recklessly and with the knowledge that such loss would probably result. Now, the loophole here basically means you can't break the limit just by proving, for instance, that the captain was drunk or the crew was negligent. You must also prove that the owners, the management board level, knew about a specific danger and decided to ignore it. The other route that you could go down is the criminal misconduct route. Okay, so in order to break the liability cap, if you can prove criminal misconduct, then the CLC limits may be able to be broken. Now, this is where the Prestige incident came in. Now, the Prestige itself was a disaster that happened in 2002. It's probably the most significant case in maritime compensation law because it successfully bypassed the unbreakable limits of the 1992 CLC. Now, although we've talked about these limits being as high as $1 billion, don't forget that the $1 billion only kicked in after the Prestige event, and prior to that the limit was much lower. So at the time of the incident, the Prestige, relatively small 42,000 ton tanker, was governed by the two first international layers of compensation under CLC, so under the 1992 fund, because it was a tanker with a cargo on board. So under the 92 protocol, the ship owner's liability was capped based upon tonnage, and at the time for the Prestige, this limit was approximately $27 million. Okay, the London P&I Club fundamentally deposited that amount into a Spanish court in 2003, as they knew they would hit that limitation of liability pretty much straight away. The second tier, the international tier, that was available at that time, so November 2002, which Spain, of course, was party to the 1992 Fund Convention. Why do we keep mentioning Spain? Because this happened off of the Spanish coast. That provided a second layer of compensation up to approximately $200 million at the time. The problem, though, was that when this ship spilt its oil, the damage and costs were estimated to be over $4.4 billion US. Yeah, so even the combined international pot of 222 million under the first two tiers that were available at the time covered less than 5% of the total loss. So what happened there? Well, the Prestige was sailing off of Spain in heavy weather. The accident report indicates that on November the 13th, 2002, the crew heard a loud explosion-like noise and that noise was the sound of the starboard hull plating tearing away from the internal structure. Now, a 35-metre gash opened up in the hold, specifically at number 2 and number 3 starboard wing tanks, which caused an immediate and severe 25-degree list to starboard. To prevent the ship from capsizing, the master intentionally flooded the opposite portside ballast tanks, which stabilised the ship, but unfortunately subjected the hull to extreme stress levels, which were later calculated at about 154% of the allowable bending moments, and this eventually caused the vessel to fail, break into two and sink. There were a whole series of strange decisions that were made by various personnel, but in particular by the Spanish authorities, who insisted that the ship was towed 125 miles off the coast in order to be worked upon. When the salvors were eventually allowed onto the ship, and they were stopped from going onto the ship by the Spanish authorities, when they finally got there, their expert opinion was that the ship should be brought into calm waters where repairs could be made, where the oil could be lighted off the ship onto other tankers, and the ship structure made safe and the ship fundamentally salvaged. That was never allowed to happen. The Spanish authorities did not allow the vessel to come anywhere near the Spanish coast. Essentially, Portugal as well refused entry to the ship, and at the end of the day, the ship was towed right out to sea by the salvors on the instruction of the Spanish government, and eventually the hull failed, the two halves sank, and we had this massive oil spill that affected the coastline of Spain, France, and Portugal. Estimations were between up to 250,000 seabirds were affected. Fisheries were closed for months. 2,500 jobs in fishing were lost. Loss of $4.3 billion to the local economy, fishing economy there, and the clean-up was so extensive of the coastline there that because persistent oil clings to everything, they ended up with over 180,000 tons of oily waste. That's how much oil was recovered from the ship itself. So obviously the low limit of 200 million was nowhere near enough to pay for all of this, and at the end of the day, Spain had to fork out the rest of the money. But Spain wanted to get more money back from the ship owner. So Spain went down the route of proving that the master was guilty of a criminal offence. Now, this plays into a lot of the loopholes that we discussed earlier on, in particular playing into the loophole that at the end of the day, the master was found guilty of reckless criminal damage to the environment, and they managed to pierce the corporate veil as well by saying that the company themselves, which were apparently a company called Mare Shipping Incorporated, were also reckless in that they allowed the ship to sail, even though the ship had shown that there was a problem with number 2 and 3 wing tanks on the starboard side. That's why they didn't contain any oil, and when the ship's side was peeled off, the water poured in, causing this massive list. So there was direct action against the insurer as well. So despite what I was saying about P&I clubs earlier on, the Spanish government moved against the London P&I club and made them directly responsible for the full amount of the insurance policy, which jumped up to $1 billion, rather than the much lower CLC cap and the resultant international fund top-ups. This, of course, shocked the world because it meant that the virtually unbreakable limits of these liabilities had been breached, and so in 2021, the IMO brought out a unified interpretation of these resolutions to reiterate that once you had reached the top, that was it, and that the ultimate shield for marine insurers should be these liabilities, and they should not be able to be breached. Obviously, a bankrupt ship owner can't pay these kind of liabilities, and at the end of the day, the Prestige case still bounces around in English courts every now and again, because the London P&I Club successfully argued in the UK that they're not liable for the 1 billion because their contract includes a pay to be paid clause, which is what I was talking about earlier on, which is where the ship owner makes good on the liability and then the P&I Club pays the ship owner, meaning that they only reimburse that ship owner after the owner pays the victim. Obviously, with such a devastating bill to pay, the ship owner went bankrupt and couldn't pay anywhere near the 4 million. The London P&I Club technically said that it owes nothing beyond the original CLC limit because the ship owner didn't pay in the first place. So lots of different tricks and loopholes at play there. So let's go back to that original article that prompted me to look into all of this. And fundamentally, the CLC defines a ship as any seagoing vessel and seaborne craft of any type whatsoever constructed or adapted for the carriage of oil in bulk as cargo, provided that a ship capable of carrying oil and other cargo should be regarded as a ship only when it is actually carrying oil in bulk as cargo and during any voyage following such carriage, unless it is proved it has no residues of such carriage of oil in bulk on board. Okay, now the Beau Dubai was a ship that basically spilt approximately 217 tons of bunker oil in the port of Rotterdam. Now, although it was a tanker, it was unladen at the time. It was on a ballast voyage, and therefore, when it came to the clean-up and the limitation of liability, the owners of the Beau Dubai turned round and said, well, we're not carrying cargo, and therefore we're going to limit ourselves under the Bunker Convention. Yep, so we're going to limit ourselves to that 65 million and not incur anything else beyond that. But at the end of the day, the Netherlands Supreme Court found that because the Beau Dubai could not prove that she was free from residues from the previous voyage, she was indeed covered by the 1992 convention and therefore subject to the much higher liability levels that came with that convention. So basically the ship owner was saying, we weren't a tanker at the time that this happened, and the Supreme Court said, yes you were, because you cannot prove that you didn't carry oil residues from the previous cargo at the time, therefore the 1992 Civil Liability Convention applied, i.e. the higher limitation of liability applied, and people could claim more money from the ship owner, the registered owner. Don't forget, it limits who you can go to under CLC, but nonetheless the registered ship owner for the higher limitation of liability under the 1992 fund, rather than under the 2001 Bunker Convention. How does a ship prove that it was free of residues? This is all about the oil record book at the end of the day. Oil record book part 2, as we know, is an oil record book that talks about the amount of oil that the ship loads and discharges as cargo, including the amount of oil that is associated with residues, tank cleaning and things like this. So as long as a vessel undergoes cleaning and flushing of its cargo tanks, slop tanks, residue oil tanks and associated pumps and pipelines in accordance with Annex 1 of MARPOL, and any oil, tank washing or oily water mixtures have been discharged or transferred off the vessel, the completed oil record book must show this. It must be countersigned by the master as required under MARPOL, and this will form the prima facie evidence that the vessel is free of residues. Unless this has been done, then it's very, very difficult to prove that a tanker was free of residues, therefore difficult to prove that the tanker was not operating under the 1992 Compensation Fund, and therefore the limitation of liability is much, much higher, as we have discussed, rather than the limitation of liability under the Bunker Convention. It's interesting. We go to the pumps and in the petrol station, and we put the diesel or the petrol in our cars. We pay the attendant, and off we go. And I think sometimes we forget how much happens in the background when it comes to the ability for ship owners to operate their ships and bring the oil into the country or bring the oil to the terminal in order to have it refined to be put into our cars. And these limits of liability funds, the 1992 CLC fund, the 2001 Bunker Convention, they are there essentially to protect ship owners so that they can continue to move the oil around, so we can continue to have that oil at our pumps. And sometimes it's worth bearing in mind that although when we see an oil spill, it tugs at the heart when we see birds that are covered in oil, when we see people losing their businesses. If we didn't limit the liability to ship owners, then ship owners would just not be able to afford their insurance and perhaps would not be able to afford to run the ship. Therefore, we wouldn't see as much oil coming into the terminals, and therefore the price that we pay as Joe Public going to the petrol station down the road would be massively increased. It's a web of law, it's a web of practice, and ultimately international funds are there to help, but they are not the silver bullet for an oil spill, which is why it's vitally important that any ship, whether it's carrying oil as cargo or oil as just bunker, takes every single precaution it can to avoid spilling that oil and therefore avoid incurring these huge, massive liability costs for clean-up and compensation. One last point about the Prestige. The Prestige was a single hull tanker. Yep. And she, when she started to tear apart, the oil from the centre tanks started to leak into the wing tanks and started to flow over the side of the ship. Double hull tankers were already being phased in when the Prestige incident happened, and that incident fundamentally sped up the implementation of double hull tankers. It brought forward a lot of the dates that had been proposed by the IMO for single hull tankers to be phased out. It brought that forward by a good few years. So although it was a horrible thing to happen to pretty much everybody concerned, the positive thing that came out of it was, of course, single hull tankers were outlawed, double hull tankers came into effect. A double hull tanker, much stronger construction, and when the hull fails, much less chance that the cargo is actually going to make it out to the sea in the first place. Thank you very much for listening to the latest edition here of the Maritime Education Podcast. I'm Barry Sadler. I hope you found that interesting, that talk there on compensation and insurance, and I look forward to welcoming you back to the next edition. Thank you very much, everyone. Have a great day.